Hello, Facebook. And so, look, I just want to come on really briefly and talk to you about protecting your creative genius. Protecting your creative genius and really understanding what's protected under copyright or trademark to clear up some confusion. So first, let me introduce myself. I am Shayla Jackson. I'm a trademark and business attorney, but I'm also the Purpose Police, here to serve and protect Kingdom CEOs so that you are armed and legally dangerous. Protect God's business and your business too. Look, the reality is that many people are out here armed with the wrong knowledge or just enough knowledge to be dangerous when it comes to brand protection with copyrights, trademarks, or intellectual property. And the reality is that a lot of you are about as dangerous as a toothpick. The reality is that some of you aren't dangerous at all. And the danger that you really pose is to yourself, but also to your legacy, because you don't understand how to protect your creative genius, the ideas that God gives you under copyright law and trademark law. And the reality is that you're leaving your brand exposed, you're leaving your creative ideas unprotected, and you're leaving money on the table. Hello, a righteous man leaves an inheritance for his children's children. And so when we talk about the creative ideas of God, just because you have the idea now, ideas are not protected under intellectual property law. Ideas are not protected. And so you need to understand when does copyright protection apply and when does trademark protection apply? Because both copyright and trademark protection is not based on registration. It's not based on registration, baby. That means that you have to know when you have a copyright and when you have a trademark for which protection automatically applies. And so if you don't know that, you can be exposing your creative ideas to risk and losing your rights, or someone can come in. The enemy comes to steal, kill, and destroy. He can come in and he can steal that idea, that God idea that had thousands, millions attached to it, legacy attached to it, breakthrough attached to it, all because you didn't understand copyrights or that brand. That brand that God gave you. You were branded by God. But because you didn't understand trademarks, you revealed your brand, or you didn't have the right protections in place in your contract, and your brand designer revealed your brand, and now somebody is using your brand. And because you don't understand trademark law, now you don't realize that because they beat you to use it first, and they're using it properly, you just lost your rights. Which means if you move forward to do the book or you move forward for the brand, now you're committing infringement. Now they got a legal right against you. This is why it's so dangerous to not have the right information. To be armed and dangerous is to pose a danger to yourself and your legacy. But when you're armed and legally dangerous, you got the right knowledge, strategy, and the skills to properly protect and build the business God has given you. And that means protecting your intellectual property. So if you haven't already, sign up for the Copyright This, Trademark That webinar that I'm doing next Thursday. It's Thursday, April 24th. Sign up. It's free. You can register at onedangerousceo.com/events. It's also, the link is in the caption. Register, because we're going to talk about what you can copyright and what you can trademark and break down the myths. Get rid of the myths that you believed about copyright and trademark protection. So go ahead and register. Hey, Samia, go ahead and register. And so this is how you know that you could be losing your rights, your copyrights, and leaving money on the table. Because all these years later, we still saying one fish, two fish, red fish, blue fish. Dr. Seuss is still raking in money, and he ain't even in the land of living no more. He gone, but the money is still coming in. That's the power of a copyright. But your ideas are not protected. And so you need to understand that the moment that you put your creative work in a fixed, tangible medium of expression, copyright protection applies. This video right here. Oh, okay. Look, reach on out to me through the law firm if you need trademarks. So for copyrights, like right now, this live stream is not copyright protection because is that copyright protected because it is still streaming. It's not fixed yet. But the moment I hit end and it's fixed in a tangible expression, which is an MP4, y'all. And look, I just got finished training in my membership. So that training that uploaded, once it's fixed, Zoom is going to put it in an audio. That means I don't just have one copyright. I got 2 copyrights. It's not just enough to know you got a copyright. You got to know each piece of your copyright. Some of you are leaving money on the table because you don't know every piece of your brand that's copyright protected that you can then leverage and license. You can't license what you don't know about. And you can't license and leverage what you don't own. So you have to understand, 1, when copyright protection applies, but 2, who is the owner? So there's an author, but who's the owner? Some of you are paying people to do work for you, and you get caught up in work made for hire, thinking if I paid you, I own it. No, baby, under copyright law, the rights automatically go to the author of the work, which means it can be your child, it can be your girlfriend, it can be a professional photographer. I'm just giving an example. They take a photo, they're the author of the work. That means the legal right belongs to them. And the only way you get the right is a contract. If you want to own it, you got to put a contract on it. This is why contracts are so important, because you cannot own what someone else creates if it's not in a contract. Same thing. If you own it and you want to transfer the rights, you have to have a contract in place. Without that contract, just like selling a house, ain't no title deed, ain't no deed. It ain't changing. It is not transferring ownership. So you want to transfer ownership. And look, copyrights, okay? If you're going to license, because you can have a license for exclusive licenses, meaning exclusive mean, baby, you can't date around this, me and you, ain't nobody else can use this work. You want to have a contract as well. Contracts are an important tool to protecting your brand with copyrights. But first you got to know, is there a copyright? First, you got to know, when does copyright protection apply? Because for many of us, when we do business, we're creating things. When you're in the creation process, there is no copyright protection. Copyright protection does not apply until the moment it's fixed in a tangible format. And you can have multiple parts of copyrights. So in my training that we did last month, we actually, and I might actually do this in next week in the webinar. So if you have not signed up and you're a Kingdom CEO, sign up for the Copyright This, Trademark That webinar. Because I have some exercises for you that I'm going to train you in how to spot whether you can copyright this or trademark that. And so one of the examples I gave was a podcast. A podcast has 3 interviews. Each interview is with a different person. That's 3 different copyrights, y'all. That's not one copyright. That's 3 different copyrights. But then you put the whole package together, the whole podcast as a whole, a composite, that's another copyright. Individual, you got multiple copyrights, multiple. Now, let me say this, because people are using AI. Copyrights require it be created by a human person. If it ain't created by a human, it ain't copyright protected. So all of y'all using AI to create your logos and all, it ain't copyright protected, which means anybody can use it and you can't stop it. Oh, but let me hit you with this. Something that is created by AI that may not be protected under copyright law could possibly be protected under trademark law. So your logo created by AI may not be protected under copyright law, but maybe, just maybe, you might be able to protect it under trademark law. But understand this, trademarks are not automatic. Trademarks are not automatic. Trademarks require that they have to be distinct enough. They got to stand out. If your mark is similar to someone else and it's like in a similar trade channel related to goods and services, chances are you can launch, and that's trademark infringement. It's not if it's the same. You can't just add a couple of letters and think, oh, it's you can't add a couple of letters and think, oh, that's a trademark. No, everything in your business is not a trademark. It has to function as a trademark. And so trademarks have to act as a source identifier. Now, let me hip you to game. If you decide that you're going to launch at a trademark, one, it cannot function as a design. It has to, when I see that mark, I associate that product or service as belonging to your business. I see it, associate it. That's where we get the Nike swoosh. That's where we get the McDonald's M. I see it and I know it's McDonald's. I recognize it. But if you're going to use a mark, be consistent. Many of you are DIYing your trademarks, and because you have not settled into your brand, you don't realize that you go register a trademark. You wasted money because now you're about to rebrand because you didn't lock into your brand. So now you just wasted money because you didn't understand that a trademark has to be, when you get ready to launch, it has to be the same mark that's registered. The moment you start changing that mark is the moment you get a new trademark. And it's based on use. Trademark protection is not based on first to register. It's based on first to use. So just because you see a mark that's registered, and it might be the same mark, but if you got prior use rights, your rights precede their rights. But you got to know, does trademark protection apply? That's why you have to understand, okay, what's eligible as a copyright and what's eligible as a trademark. Can I tell you that titles of books are not protected under copyright law? But baby, if you do a series like Chicken Soup for the Soul did, it might be protected as a trademark. Now you got protection. This is why it's important to be armed and legally dangerous, because you can strategically put your creative ideas under a protection of a law, and then you can enforce the protection. Because copyrights and trademarks, what it does when God downloads that idea is that the power of it is that you can stop people from stealing the wealth that is assigned to your business. Do you really think the God ideas ain't attached to wealth coming in? A righteous man leaves an inheritance for his children. Why? How can you do that in business? Through the creative genius and ideas that God downloads to you, but only if you understand how to protect it under copyright and trademark law. So if you are a Kingdom CEO and you have not signed up for copyright this, trademark that, get in the room. It's free. We getting into it until next week, Thursday night. You can register at onedangerousceo.com/events. And I'll leave you with this. When the ideas are not protected, meaning copyright law hasn't attached, trademark law has attached, you're in this weird space, how do you protect the ideas? There are two ways to protect ideas. One is with a contract, meaning if you have to disclose it, then you want to use NDA or I combine them both. NDA and confidentiality, either agreement or put a clause into your contract. The NDA is a non-disclosure. It means you can't disclose it. The reason why I attach a confidentiality to it is because confidentiality imposes a responsibility that you have to take actions to make sure it's not disclosed. So NDA, I just got to make sure I don't do something. Confidentiality says, no, you got to take proactive steps to make sure don't nothing get out. Okay? That's one way you protect your ideas. The other way you protect your ideas is what I call a holy hush. A holy hush. Some of y'all talk too much. And the person that you're talking to is the snake, that snake in your friend, in your family member, in the person you think you can trust. And you don't realize that you're giving away the God thing to someone who really is a thief. Okay, look, Good Friday is tomorrow. You're giving away the good thing to the Judas in your midst, and you just don't know it's a Judas. A holy hush will protect your idea until you have properly positioned yourself that it's protected under copyright and trademark law. If somebody breaches the contract, baby, the only recourse you got is to sue them. But when somebody comes after your copyright or your trademark, you got a little bit more rights under the law if you follow the law. So I just wanted to come on really quick, give you that, how to protect your creative genius. Is it a copyright? Is it a trademark? Copyrights deal with creative works of expression. Trademarks deal with source identifier, the pieces of your brand that acts as a source identifier. I see it on a product or service. I know the source. I know the source. It's a source. It recognizes awareness. Okay. So that's all. Make sure you register for next week. Copyright this, trademark that. Y'all, we're going to be training in it. It's for Kingdom CEOs only. Get in. It's free. There will be a limited time replay available just in case you can't make the live. And that's it. I'm signing off. Y'all have a wonderful, wonderful night, y'all. Again, I am Shayla Jackson. I'm the founder of Armed and Legally Dangerous, and I'm also the Purpose Police. I am here to serve and protect Kingdom CEOs so that you are armed and legally dangerous to protect his business and your business too. And I'm also a business and trademark attorney. Again, y'all have a wonderful night. Share this if you found this helpful. And again, get in the room for next week for copyright this and trademark that. I'm excited. Whoop, whoop, whoop. All right, y'all. Good night. Good night. Good night. Good night. Good night, Lavani.